read a second time.
My Lords, I am pleased to present the Post Office Horizon Scheme Offences Bill for second reading today. Noble Lords will have followed the passage of this historic bill through the other place, and we will be well aware of its significance as well as the cross-party support it has received. The legislation will address one of the greatest miscarriages of justice in our nation's history. It will quash convictions of those affected by the Post Office Horizon scandal in England and Wales, and, following government amendment in the other place, in Northern Ireland too. This will ensure postmasters are not disadvantaged by the unique challenges of expediting legislation which are faced by the Northern Ireland Assembly. The Government will continue working closely with the Scottish Government to support their approach to addressing the scandal, ensuring that every postmaster who has been affected, irrespective of where they are in the United Kingdom, receives the justice they deserve. The financial redress scheme will be open to postmasters throughout the UK regardless of where or how their conviction was quashed. This bill will clear the names of postmasters whose life were destroyed because of the Horizon scandal, those who received wrongful convictions or cautions for offences, including false accounting, theft and fraud, because of the Post Office faulty IT system. This legislation cannot undo the damage caused by the Horizon scandal. However, it is a crucial step in restoring the good names of those affected and ensuring they can access fair and full redress. My Lords, this new legislation will quash all convictions which meet the following clear and objective conditions: that the case was prosecuted by the Post Office, the Crown Prosecution Service or Northern Ireland's prosecuting authorities, that the alleged offence was committed between certain dates in 1996 to 2018, that the postmaster was convicted of theft, false accounting or similar offences listed in the bill, that the convicted individual was working in a post office which was using the Horizon system, and the alleged offence was carried out in connection with running the business of that post office or with the person's work in that post office. The bill will not quash convictions that have already been considered by the Court of Appeal as defined in the bill. The safety of these convictions has been considered by judges in the Senior Appellate Court. The Government's view is that, given the constitutional sensitivities, extreme caution must be exercised over whether Parliament should interfere with these decisions. Convictions will be quashed automatically when the bill receives royal assent, removing the need for people to apply to have their conviction overturned. This will ensure that those affected receive justice as soon as possible. The bill includes a duty on the Secretary of State, or in Northern Ireland, the Department of Justice, to take all reasonable steps to identify convictions that have been quashed. It also creates a duty to notify the original convicting court so that records can be updated. Other records, such as police records, will be amended in response. Similarly, the bill also makes provision for records of cautions relating to the scandal to be deleted. My Lords, I am well aware the approach we are taking in this bill is novel. In this bill, we are using legislation to fulfil a function that in normal circumstances is rightly reserved to the independent judiciary. I am equally aware that these are not normal circumstances. Given the number of postmasters involved, the passage of time since the original conviction, the loss of evidence over that time, and the loss of trust in the system, meaning many affected simply will not come forward to appeal, it is right that the state provides an exceptional response. Postmasters have suffered too long, and we must end their fight for justice as swiftly as possible. However, it is vital to make 2 points clear to your Lordship's House. First, the Government's position is that it will be Parliament and not Government that is overturning the convictions. There will be no intrusion by the Executive into the proper role of the judiciary. Second, we have been clear throughout the passage of this bill that this legislation does not set any kind of precedent for the future. It is also important to be unambiguous that the passage of this bill is in no way a reflection on the courts or judiciary, which have dealt swiftly with all the cases before them. So, my Lords, upon royal assent, this legislation will quash all convictions in its scope with immediate effect as a matter of law. This means that victims will not have to take any action to receive exoneration. It also means that this unprecedented provision expires once it's done its job on the day of royal assent. That supports the government's aim that this bill should not be seen as a precedent for Parliament acting outside its usual constitutional role. The government will take all reasonable steps to notify the relevant individuals and direct them to the route for applying for financial redress. Further details of this process will be set out in due course. Importantly, there will also be a process for anyone to come forward where they believe their convictions meet the criteria. If they meet the criteria in the bill, their records will be amended to reflect the quashed conviction in the same way. Turning now to financial redress, this new legislation will be followed by a rapid route to financial redress on a similar basis to the existing redress arrangements for those with overturned convictions currently administered by the Post Office. However, the government, rather than the Post Office, will be responsible for the delivery of the scheme for those whose convictions are overturned by this bill. Final decisions will be made by independent panels or individuals where they cannot be agreed with the postmaster. We do not need provisions in the bill to deliver that scheme. The legal basis on which redress is made is already in place. We place great importance on ensuring that this redress is delivered promptly. Information about redress will be provided to each individual alongside the notification that their conviction has been overturned. Each exonerated postmaster will have the choice between accepting a fixed offer of £600,000, which will be paid rapidly, or having their claim individually assessed. This new scheme will join the 3 schemes already being run by the Post Office and my department. In total, over £200 million has already been paid out to over 2,800 claimants. 72% of claims received have been settled, but the government continues to strive to accelerate matters. Ministers are advised on these issues by the Horizon Compensation Advisory Board. We're very grateful to the board's members, notably the noble Lord Arbuthnot, in his usual place, who has done so much to drive the resolution of the scandal. So, in summing up, my Lords, this bill amounts to an exceptional response to a scandal which is wholly exceptional in nature. It is a scandal which has shaken the nation's faith to the core in our core principles of fairness and equity which underpin our legal system. We recognise the constitutional sensitivity and unprecedented nature of this legislation, but we believe that it is essential for us to rise to the scale of the challenge. The hundreds of postmasters caught up in this scandal deserve nothing less. Of course, no amount of legislation can fully restore what the Post Office so cruelly took from them, but I hope this bill at least begins to offer the closure and justice for which postmasters have so bravely campaigned over so many years. I hope that it affords them the ability to rebuild their lives. My Lords, I beg to move.
The question is that this bill be now read a second time.
My Lord, I thank the noble Lord the Minister for setting out the provisions of this piece of very important legislation in such plain language. I think that most, if not all, of your Lordships understand what this bill sets out to do. My Lords, I feel honoured to have the opportunity to be the first speaker from these benches to welcome this bill. Particularly I do so when I see that who all but one other is the next speaker in your Lordship's debate. My admiration for the noble Lord Arbuthnot of Erdrum goes back even before his work on Horizon, but I admire him greatly for what he's done and is, I think, deserving of the recognition that work that he and my noble friend Kevin Jones did for years now in trying to get proper redress for this egregious miscarriage of justice. My Lords, there is no doubt that the Post Office Horizon scandal is, if not one of the worst miscarriages of justice in British history. I think I remember correctly in January when the Prime Minister made a public statement that this bill would come before Parliament. I think he described it as the worst miscarriage of justice in British history. I'm inclined to agree with him. I don't always, but in this case, I think I do. My Lords, as we know, it robbed many people of good character, it robbed them of their livelihoods, their liberty, and in some cases their lives. And because of the nature of this damage that was done to the sub-postmasters, that has been carried down and will be carried down in generations of their families. It has influenced very badly the families of these great public servants. It caused unimaginable pain and suffering which can never be fully compensated or fully alleviated. And to make matters worse, the fight for justice for the sub-postmasters has become bogged down in a great many delays and barriers, and some of those affected tragically, as I've already alluded to, have passed away before having the chance to see the justice that they deserve. What we do know, my Lords, is that this bill will free hundreds of innocent people of their wrongful convictions. It won't restore their character because that can never properly be fully restored, but it will give them an opportunity to try to put it behind them. And importantly, it facilitates the opportunity to make much needed progress in otherwise righting the wrongs. These reasons, my Lords, are the reasons given by my noble friend Jonathan Reynolds in the other place, and they are why Labour will give this bill our full support. However, not only must the convictions be overturned, but thereafter compensation must be delivered at pace. And justice and accountability must follow from the conclusions, my Lords, of the independent public inquiry that is ongoing and their recommendations. My Lords, I was struck by the words of Sir Robert Buckland during the second reading in the other place. I think on more than one occasion in debates and questions on these issues he has hit the nail on the head. In his first intervention he said it's important that we emphasise the wholly exceptional nature of this legislation as we are dealing with wholly exceptional circumstances, described I think very clearly by the noble Lord the Minister. But I also agree, my Lords, with his emphasis that we have to look again at our evidential presumptions about machines and what they produce in criminal litigation. My Lords, this is unfinished work and should be done in lockstep with the work that's being done to try to resolve the challenges of Horizon. My Lords, I do wish to pause just for a moment from talking about the bill itself, just to recognise the work of many people who have got us to this landmark occasion. I think, my Lords, the postmasters themselves demand a great deal of credit for that. I cannot imagine what it must have been like for people who had been so badly damaged to pick themselves up and fight over the tens of years that some of them have in order to get not just justice for themselves but justice for their colleagues. I think they are the people who deserve the greatest amount of credit, but I've already referred, my Lords, to the noble Lord, Lord Arbuthnot, but I'm looking at this paper because I want to get this committee properly. The Horizon Compensation Advisory Board requires a great deal of credit for getting us. If I understand the chronology of how we got here in the last stages, it was their letter of December of last year to the Minister, explaining in some detail just how difficult it was for anybody to get redress in the Court of Appeal, and the degree to which I think the statistics showed at that stage when they wrote to the Lord Chancellor that there had been 900 prosecutions, but only 93 people at that stage had had their convictions overturned. I can't work out what that meant, how long it was going to take, but I did overhear somebody recently say that it was looking like about 50 years before at the pace that these convictions were being overturned, it was going to take the appeal court process to do them. But for the reasons set out in their letter, the committee told the Lord Chancellor that the only viable approach was to overturn all the Post Office driven convictions. Remarkably, my Lords, within a matter of days, Kevin Hollingray, the Minister with responsibility for this, was taking legal advice, he said, as to what could be done. And by the 10th of January, the Prime Minister was announcing publicly that this bill would be brought before Parliament. That's anything would be fast compared to the alternative that was going through, but that's remarkably quick for a government with a number of people that have to be satisfied, and I congratulate and thank all of those persons who were involved in that, getting us to where we are. My Lords, this is in many ways a very unusual piece of legislation, but it is unusual in this sense, my Lords. I don't think anybody will be able to make a speech that says that this has come to this House not having had the attention it deserved in the House of Commons. I know they did it all in one day, but they did go over this bill very, very carefully, I thought, and I think they deserve some credit for that. There's not much about it, my Lords, that I think we'll need to look at carefully. Although I did get a letter, an email rather, from the Law Society that set out, have it here, I'm sure all the members whose names were on the speaking list probably got it. But it goes on for about 4 pages. I got it on Thursday. I haven't had a chance to consider it, but the Law Society recommends some probing amendments in order to reinforce the idea that this is not a precedent. I don't think it really needs reinforced, to be honest. I think enough ministers have said enough at the dispatch box about that for people to be able to establish that it is a precedent. However, I have to say, and I am a recovering lawyer myself, I'm a bit disappointed, although this is not my Law Society, but I'm a bit disappointed there wasn't a word in it about the number of lawyers who have been involved in getting us to where we are. But I'll be in correspondence with them, my Lords. I'll raise that point with them and ask them maybe at some point they might want to say something about the number of lawyers who must have been involved in helping create this system that's got us to where we are. Anyway, my Lords, I don't intend to speak for very much longer. Noble Lords will be pleased to hear, but there are basically two points I want to make, which I think we should consider. I fear that the issue of extending this bill to cover Scotland will come up again somewhere in our debates. The Justice Minister in the Scottish Government, the former First Minister, Humza Yousaf, and any number of members of the other House that are in the SNP have used some quite critical language about the government and about this Parliament for not extending this bill to Scotland. I think the simple answer to that is just to remind them that justice is a devolved matter in Scotland. You normally defend devolved matters quite strongly, but justice is a devolved matter. Secondly, the Lord Advocate, a woman who I know very well and is a very good lawyer, and just for those of you who don't know what the Lord Advocate does, because this is important to their requests that the bill be extended to them, the Lord Advocate is, among many other things, the principal legal advisor to the Scottish Government. She is also the head of the System for Investigation and Prosecution of Crime in Scotland. Essentially, she is the public prosecutor. And she spoke to the Scottish Parliament at length about the Horizon cases. She made a statement to them on the 16th of January 2024. I won't read it all to your Lordships because it's about 4 or 5 pages long, but the important part of it is that the Scottish Government's own legal advisor, And the head of the prosecution service said, and I quote just 3 sentences, "It's important to recognise that in Scotland there is an established route of appeal in circumstances such as this," having spelt out the circumstances of the arising case as far as they apply to Scotland. That route involves the SCCRC, that's the equivalent of the committee in England and Wales that looks at cases before sending them back to the appeal court. The route involves the SCCRC considering cases in the first instance prior to referring appropriate cases to the Court of Appeal. This is an important process because not every case involving horizon evidence will be a miscarriage of justice, and each case must be considered carefully and with regard to the law. It's also important to recognise the important and established constitutional role of our appeal court in Scotland, and that due process must be followed. So that's the government's lawyer's position, and she's part of the government. That's how it should be done. There is another way in Scotland that it could be done, and that is that she could, as the prosecutor, say to the Procurator Fiscals and to the Crown Office, look at these cases, tell us whether they can be sustained in appeal, and if they can't, just take them to the appeal court and tell the appeal court you no longer stand by these convictions. There is a very simple, in my view, and this is a view held by many lawyers in Scotland, way for the devolved administration in Scotland through its existing prosecutor system to get these cases dealt with. Final point I would like to put to the noble Lord is, why do we persist to exclude those who have had their convictions held up by appeal from this bill? There is no doubt that the public inquiry has revealed considerable further evidence since those appeals were refused. There is no question. If any of those cases involve horizon-generated evidence, they should be given the same consideration as the cases that have been prosecuted to conviction but not appealed. And every single witness who gave evidence to the Justice Committee in the other place when it was considering this bill said that should be the case. I just urge the government to reconsider that issue. I have nothing further to say. I will participate in other debates, but I'll continue to support this bill.
My Lords, the wrongful conviction of sub-postmasters and mistresses as a result of prosecutorial misbehaviour has caused personal harm, indeed tragedy, and a national scandal. Wrongful convictions must be quashed, and a bespoke process is necessary to accelerate justice. But the legislative solution His Majesty's government has chosen was described in a written statement in February by the Minister, Kevin Hollingrake, as raising constitutional sensitivity and being unprecedented in nature. The constitutional sensitivity arises from the fact that Parliament does not quash convictions. That is a matter for the courts. What this bill proposes is indeed unprecedented since the constitutional settlement which followed the Glorious Revolution at the end of the 17th century. The Lord Chancellor, in his recent appearance before the Constitution Committee, said that anyone who cares about the system has misgivings. Indeed they do. In the House of Commons, Sir Robert Neal said that, frankly, it is most undesirable that we should go down this route. And the Minister responded by saying, "We agree that this is unprecedented and undesirable, but we believe it is the least worst option." My Lords, I endorse the government's sentiment that this legislative proposal is undesirable, but not that it is the least worst option. An alternative scheme, which would have kept within the well-understood constitutional boundaries which separate the roles of executive parliament and the judiciary, was considered but rejected by the government. I declare an interest in having sketched out such a scheme in early February, and will identify its key features, if I may, in a few moments. But first, it might be useful to bring together some of the facts. The bill seeks to capture 950 or more convictions over a period of a little more than 20 years. The helpful library briefing note tells us that the Post Office has identified 730 individuals it prosecuted where evidence from Horizon may have been used. The balance was prosecuted by the prosecuting authorities in England and Wales, in Scotland and Northern Ireland. I shall focus on England and Wales, which accounts for most of that total. Those cases were pursued in the Magistrates' Court as summary offences and in the Crown Court on indictment, about half in each court. In answer to a question on Radio 4 on the 26th of March, the Lady Chief Justice explained that in over 90% of the cases, the defendants had pleaded guilty. The High Court judgments in civil proceedings before Mr. Justice Fraser in Bates and the Post Office at the end of 2019 exposed the flaws in the Horizon system. The first tranche of appeals in the Court of Appeal Criminal Division in 2021 revealed more flaws. The evidence heard by the public inquiry has raised further questions about non-disclosure, the suppression of evidence, and worse. And so the original grounds of appeal to the Court of Appeal are now much expanded. Over 100 appeals have been allowed in England and Wales, about 3/4 in the Court of Appeal on appeal from the Crown Court, and about 1/4 in appeals from the Magistrates' Court to the Crown Court, sitting in its appellate capacity. Some have involved appeals brought out of time by the convicted defendants themselves, others references by the Criminal Cases Review Commission. A few appeals have been dismissed by the Court of Appeal because the court concluded that the conviction was safe. That is the statutory test. An appeal to the Court of Appeal will be allowed only if the conviction is unsafe. By contrast, an appeal from the Magistrates' Court is a complete rehearing. If the prosecution does not call evidence, the appeal will be allowed. No appeal to the Crown Court from the Magistrates' Court has been contested by the prosecution. Both the Post Office and the Criminal Cases Review Commission have contacted all those they can identify to help to get their cases back to the appeal courts. The response has been disappointingly poor. Many may just have had enough. That has raised the question, what to do? The government's answer is this bill. But what of the alternative? The outline was simple. Legislate to confer power on the Secretary of State to refer cases to the relevant appeal court if she considers that the conviction may be unsafe. That could include cases already that have gone through the courts. Give the Court of Appeal Criminal Division the powers of the Crown Court sitting in its appellate capacity so that all appeals could be dealt with in one place. The burden on an appellant from the Crown Court to the Court of Appeal is to demonstrate that the conviction is unsafe. Of course, the reality is that if an appeal of this sort were not contested in the Court of Appeal, the appeal would be allowed. But any doubt about that could be resolved by reversing that burden with a statutory presumption that the conviction is unsafe. The prosecution would then have to rebut it positively to sustain the conviction. The appellants would need to do no more than identify the grounds upon which they rely, now almost pro forma. to cater for those cases where a defendant has died or lacks capacity. The Attorney General could be given a representative role. On this scenario, the Secretary of State would be able to inform all those whose cases she intended to refer. Representation could be lined up. The cases would go through the courts en bloc and be dealt with swiftly. What then of the objections? At the heart is the proposition that many of those affected will not initiate proceedings. But the outline scheme caters for that. Next, it is suggested in the explanatory notes that the appeal, and I quote, relies on there being sufficient evidence that the conviction is unsafe, and in many cases that evidence no longer exists, close quotes. The reversal of the burden in the Court of Appeal caters for that, and in any event, the point does not run for appeals from the Magistrates' Court. I have also heard it suggested that the courts could not deal with these cases quickly. That has been flatly contradicted in public by the Lady Chief Justice and is confounded by the speed at which appeals are being dealt with at the moment. Now, my lords, all schemes have rough edges, but for the sake of conforming to accepted constitutional norms, one of the nature I have outlined would, with respect to the noble Lord the Minister, be preferable. It would avoid the executive inviting Parliament to do something about which ministers themselves have described as having misgivings on constitutional grounds, and have described also as being undesirable. It would also avoid one of the anomalies of the bill, namely that there is no scope to exclude convictions which are sound. As Sir Robert Neal has pointed out, the bill sets out to quash convictions even if horizon evidence did not form part of the prosecution. That's right. Condition E is simply that at the time of the alleged offence, the horizon system was being used for the purpose of the post office business. Not was being used by the defendant, nor that it was material to the conviction, but simply that it was there. There may be no horizon evidence at all in many cases which this bill would quash. And so this bill would quash convictions not affected by the horizon scandal. My lords, it might be thought that that matters not only for constitutional reasons, but also because of the government's plan, as the noble Lord the Minister has explained, to give anyone whose conviction is quashed by this legislation at least £600,000. My lords, it may be that this bill can be improved by amendment, but its flaws are fundamental. It seeks to achieve a desirable outcome by a novel and unconstitutional route when a satisfactory alternative is available. It will provide food for academic debate and long feature in university courses on the rule of law, independence of the judiciary, and the separation of powers. The repeated suggestions from government and also from opposition that it provides no precedent are perhaps the clearest indication that the proponents know it's wrong in principle to ask Parliament to quash convictions. But, my lords, it does provide a precedent, as no future Parliament can be bound by what is said in connection with this bill. My lords, whether any politicians in the future will try to use it as a precedent is something we shall have to wait to see.
I declare an interest as a member of the Horizon Compensation Advisory Board, although I think it has now been renamed the Horizon Redress Advisory Board. It is a genuine honour to be able to follow a speech like that from the noble and learned Lord Burnett. And I'm grateful both for what he said and for the immense amount of work that he has put into this most terrible of problems. I want to comment on some of the points he made during these remarks, but I'm grateful to him. In the face of one of the most widespread injustices of this country, we all know the background, we needed to do something. This bill is the government's answer, and I welcome it. I'm extremely grateful to my right honourable friend, the Prime Minister, to my noble friend, the Minister, in this House, and also to the Post Office Minister in another place, Kevin Hollinrake, for their astonishingly fast appreciation of the need for urgent, dramatic action and for following it through in this way. And I'm also grateful to my right honourable friend, the Lord Chancellor, for having some really difficult discussions, as we have just heard, with the judges about this. As the noble and learned Lord Burnett has told us, the bill could have gone two ways. It could have gone his way, or it could have gone the way it has. The argument in favour of involving the judges based on the separation of powers has been carefully set out by the noble and learned Lord. It's an uncomfortable thing. Some would put it much stronger, to have the legislature overturning decisions made by the judiciary, because that could form a constitutional precedent, and I accept it does form a constitutional precedent, which would take us in the direction of totalitarianism. My lords, I'm not going to express a preference between the noble Lord Burnett's suggestion and the government's suggestion in this legislation, because this is the bill that we have, and I am thankful for it. I understand, of course I do, the constitutional difficulty of Parliament overturning judicial decisions. I practiced as a barrister, my wife is a judge, I value the separation of powers, but I also value timely justice and the early reversal of some of the greatest unfairnesses that this country has ever seen. But I do want to set out the arguments against involving the judges, if only for the record. I do accept that the points made by the noble and learned Lord Burnett do deal with many of the points I'm about to make. But as I say, and as I know he accepts, we have the bill that we have. The Fraser judgments in Alan Bates's group litigation came out in 2019. The clear consequence of those judgments was that many hundreds of convictions were unsafe. We don't know exactly how many, which is odd, but it was in the region of 1,000. And yet, by the beginning of this year, only a few over 100 sub-postmasters had even applied to have their convictions overturned. And there were several reasons for this. The first and the most important was that too many sub-postmasters wanted nothing whatsoever to do with a court system which had, in their view, treated them so badly. They had been utterly traumatized. They wanted to put the whole ghastly experience behind them. They were simply not applying to have their convictions overturned. They wanted no contact with officials, lawyers, politicians, journalists, nor anybody else at all, for understandable reasons. Yet appeals rely on the appellant applying, and the current system has no procedure for mass appeals brought by the state itself. I didn't quite get to the bottom of what the noble and learned Lord was suggesting in order to redress that, but it would have probably been workable. Nevertheless, we have the bill that we have. The second reason for not involving the courts was that in many cases there is no evidence. In some cases, the Post Office will have taken the evidence away from the sub-postmasters and destroyed it. In other cases, the sub-postmaster himself or herself will have given up and destroyed it. In yet more cases, the sub-postmaster will have died. But in order to overturn a conviction on the basis that it is unsafe, you need to establish with evidence that it is unsafe. The noble and learned Lord Burnet's suggestion of a presumption of unsafety is one of which I approve, but we have the bill that we have. The third reason was that appealing against convictions has to be done through several different stages, going to the Post Office, then the Criminal Cases Review Commission, then the court at different levels, with the application of different tests, sometimes leading to different outcomes, which is strange in itself, and the noble Lord Burnet touched on this. And the fourth reason was that the Court of Appeal was overturning only those convictions for which horizon computer evidence was essential to the prosecution. That was an arguable limitation, although in my personal view wrong and unfair, in the earliest stages of the process. But as the public inquiry has uncovered new facts about the behaviour of the Post Office, I suggest that it is a limitation which is no longer tenable. I tread carefully here because the inquiry has yet to report, but it seems that the Post Office investigators, incentivised as they were to recover money rather than to achieve justice, and the Post Office lawyers, intent on concealing evidence, tainted all the evidence produced by the Post Office in any trial. The deaths of many of the sub-postmasters makes me remind your lordships that this is urgent. We have to get on with it, and this bill does that. This bill quashes certain convictions, and by doing so, it gives rise to redress being paid to hundreds of sub-postmasters. The bill doesn't itself deal with that redress, but when people say that only a small proportion of sub-postmasters have received redress, they are right, but that will rapidly change with the passage of this bill. It's an essential step to getting us to where the country wants us to be. The question of which convictions are to be quashed is a difficult one, but nothing about this saga is easy. The bill quashes convictions in England, Wales and Northern Ireland, but not in Scotland, and I listened with interest to the noble Lord Brown's suggestion as to how the Procurator Fiscal could operate in Scotland. The Scottish Government is itself legislating to achieve something similar, and I hope that that can be looked at carefully in committee. Those quashed convictions under this bill have to have been prosecuted by the Post Office or the CPS or Northern Ireland authorities, but those prosecuted by, for example, the Department of Work and Pensions are not included. This too needs careful consideration in committee. Certainly the DWP will need to give very careful thought to the extent to which it relied on Post Office evidence and investigations, and to consider whether the convictions it secured were any more safe than those secured by the Post Office and the CPS. Should we consider, perhaps in committee, widening the scope of the bill so that those convictions too are overturned? I have to say, I don't know. I should very much like to hear why the government considers that DWP convictions are safe when CPS convictions are not. And I should also like to hear what the DWP is doing to re-examine their convictions to ensure that they have not relied upon tainted Post Office evidence and investigations. Another category of convictions not quashed by this bill is those that have already been considered by the Court of Appeal. I listened carefully to what the noble Lord Brown said about this, and I agree with what he said. There are 13 of these cases. I'm very uncomfortable indeed about this for the following reason. The bill overturns many hundreds of convictions. The government accepts, as it should, that some of the convictions overturned will in fact have been of sub-postmasters who were actually guilty of a crime. That is the price that we pay for the exoneration of the innocent. Those who have been in front of the Court of Appeal, in exactly the same way as those sub-postmasters who have been in front of other courts, may or may not be guilty. I don't think it's acceptable to tell them you can go back to the Court of Appeal if there is new evidence, because other sub-postmasters are not being required to provide individual evidence of their innocence, a reversal of the burden of proof. These sub-postmasters, these 13, are being punished for their efficiency and courage in being early in taking their convictions to the Court of Appeal. There is, of course, one new bit of evidence which the Court of Appeal did not consider in relation to these 13 cases, and that is that all the sub-postmasters other than these 13s are about to be exonerated. It stretches credulity to believe that the Court of Appeal would say, of all of the hundreds of convicted sub-postmasters, these are the 13 that we would choose to remain convicted. Can it be fair that they should be the only sub-postmasters in the country to be left with convictions? And I can't see that the Court of Appeal would welcome a new application from them, because how could the Court of Appeal consider anything other than the facts of these individual cases? This is a matter which we shall need to consider very carefully in committee. My Lords, the government is to be congratulated on its speed and courage in bringing the bill to us. But I first became involved in this matter in 2009, and Alan Bates in 2003. So speed is obviously a relative term. Let's get on with it.
Hear, hear. The heroes of the story is Alan Bates and the sub-postmasters, who, having been wrongly convicted, then, in order to establish their innocence, fought a piece of incredibly expensive civil litigation, fought all the way by the Post Office, who Sir Wyn Williams will tell us, if they deliberately suppressed evidence even in that. There are signs that they did. And Alan Bates won in front of a judge in the civil courts, and that began the process by which exoneration took place. Could I, like everybody else in the House, pay a tribute to Lord Arbuthnot of Edrom and also to Mr Kevin Jones? They pursued a terribly unfashionable cause for literally decades and never gave up on it. When all the establishment were against them, all the senior executives of the Post Office, the board of the Post Office, senior civil servants, ministers who didn't pay enough attention, there was absolutely nothing in it for them, and they persisted. They make one admire politicians, and they shame most of the rest of us. I welcome and support this bill. I actively support the solution that has been adopted by the government. I do not support the solution being proposed by the noble and learned Lord Burnett of Malden. I say that with enormous trepidation, because the noble and learned Lord Burnett of Malden is somebody I admire greatly, whose judgment is good, who took the courts through the pandemic, making good legal and wider judgments throughout. But with the greatest of respect to him, I think he is wrong in relation to this. The miscarriages of justice spanned a period of 22 years. The numbers of people wrongly convicted of serious offences and their lives comprehensively ruined as a result is not known. Maybe it was 700, maybe it was 900. The number of people who went to jail is not known. Maybe it was 230, maybe it was more. The period of time the miscarriages lasted, the numbers of people affected, the lack of reliable information is quite unprecedented. The destruction of the lives and livelihoods of the sub-postmasters and their families is unspeakable. The responsibility for this is first and foremost the Post Office, who pursued and prosecuted them on a false basis, and Fujitsu, who knew the truth and colluded in its suppression. As the noble and learned Lord Burnett of Malden has said, a significant number of the convictions, I don't know how many, that figure of 90% I'm not sure about, were on guilty pleas, often to a charge of false accounting. Do not be comforted by that. No doubt those guilty pleas were obtained by a combination of what lawyers would have advised the defendants was the irrefutable evidence of the Horizon system. Irrefutable not because of some principle of law, but because there was simply no evidence to undermine the system, because the Post Office had suppressed such evidence. And also the prospect of the Post Office not pursuing more serious charges if there was a plea of guilty to the lesser charge, as it was presented, of false accounting. This bill addresses only one aspect of the scandal, how to extinguish the wrongful convictions. In many of the cases, as everybody who has spoken in this debate has identified, much of the underlying written and other material has been lost, partly because the Post Office has destroyed it, partly because the defendants want to have nothing more to do with what was a terrible period in their lives. As far as the process of appealing successfully against these convictions is concerned, there has been an unspecified number of appeals against conviction in the Magistrates' Court, which have generally been heard in Southwark Crown Court. As the noble and learned Lord Burnett of Malden has said, in all of those appeals, the Post Office called no evidence, and in consequence, the appeal, being by way of rehearing, the appeals were automatically allowed. In relation to the appeals from the Crown Court, up to the end of January, there have been 106 appeals completed in the Court of Appeal. 70 have been allowed, 26 withdrawn by the appellant sub-postmaster upon sight of the Post Office's response, and 7 dismissed. I appreciate that leaves 3 cases unaccounted for, which I cannot explain, but which is symptomatic of the lack of reliable information about the scale and extent of the problem. The Court of Appeal, as the noble and learned Lord has said, accepted the unreliability of the Horizon system. Other reasons have come to light, as the noble and learned Lord has said, which would justify appeals, including and in particular the withholding of exonerating material by the Post Office in the prosecutions. As the noble and learned Lord has said, there are already well-established processes for setting aside wrongful convictions in our system. The proposal made by the noble and learned Lord is that we would let the existing processes take their course with modifications, some of it no doubt required by primary legislation. This, in my view, has a number of problems. First, it would not be possible to identify all of the cases simply because there aren't the records. Many innocent sub-postmasters would not connect with the process, whether they wanted to or not, and as a result would not be exonerated. Second, it would take time, and it would take a long time. 50% at least of the English cases would have to be dealt with in the Court of Appeal. I have absolutely no doubt that the Court of Criminal Appeal would do their bit as quickly as reasonably possible, but time would be required to identify the cases, to prepare the appeal material, to undertake some form of investigation on the part of the prosecution, and then to list those appeals. Third, as the Noble and Learned Lord has said, it was the Noble Lord Arbuthnot of Edram who said it, a significant number of sub-postmasters would refuse to participate because of their lack of faith in the system. The current system, as everybody has said, does not allow for an unwilling defendant, unless lacking capacity, to have their case referred to the Court of Appeal against their wishes. Fourth, it will be either for the Post Office or the Crown Prosecution Service, if they replace the Post Office as the prosecuting authority, to determine which of the appeals to contest. The evidence which Sir Wyn Williams is hearing in the inquiry suggests little faith can be placed in the Post Office properly performing any duty placed in it in connection with Horizon. No doubt the obligations of the prosecutor can be passed, at least in England, to the Crown Prosecution Service. But that creates yet further delay. As the Noble and Learned Lord has said, the Lord Chancellor could be given power to refer the cases of unwilling postmasters to the Court of Appeal. There could, as he has said, be a presumption the defendant was innocent unless the prosecution could actively convince the court that the convictions were safe. None of this would obviate the need for investigation within, if not by, the prosecution at a time when the material is limited. And it would not prevent some appeals being resisted on the basis of which documents had survived. The Court of Appeal could no doubt hear cases en bloc of, say, 50 or 60 cases at a time and list them within weeks of the court being told they were ready. All of this is possible, but it is bending our justice system out of its normal shape. Our justice system provides itself rightly on providing a fair and reliable system of adjudication, where above everything it decides cases on the evidence before it in accordance with settled principles of law. The courts have the key role of deciding disputes between private individuals and between the state and private individuals without fear, favour or interference of any sort, particularly from the state. Because the executive controls the legislature in our system, it can interfere with court processes by legislation. If unfavourable court decisions were overturned by legislation, the rule of law would be undermined. Not where the legislation was to change the law, but where it was to overturn an inconvenient finding of fact. And that's the argument of the Noble and Learned Lord, Lord Burnet. There are essentially three alternatives. First, legislate to exonerate, a bill something like this. Second, a royal pardon. And third, the adaptation of the current system of appeals to allow for mass exoneration by the courts. A royal pardon is inappropriate. It involves pardoning somebody for committing a crime, maybe because modern practice would not have regarded the act as a crime. The sub-postmasters did not commit the crime. They should not have pardon. They should have exoneration. Of the other two routes, I favour legislation like this, because it best does justice, which is the best protection for the rule of law. It is no criticism of the courts, and it involves neither a slur upon the judges nor the setting of a precedent which undermines the rule of law, to say the exceptional facts of this case cry out for legislation, not appeals. This legislation identifies the group, sub-postmasters convicted in connection with their post office work whilst the Horizon system operates, and automatically and immediately exonerates them. The court process will take quite time, but much quicker than normal, but for many it will take years, not months. The court process will miss people because of the bad record keeping. If it's exoneration by court, those missed, when they emerge, as many will, they will not have been exonerated. And then they will have to go through a court process when all the urgency is gone, to petition for acquittal. The court process will produce anomalies and inconsistencies, bred very often by the uneven loss of documents and the unreliability of the post office. For those postmasters who are challenged to establish their innocence wherever the burden lies in the court process, it is difficult to imagine they would have faith in the conduct of such a prosecution. My own view is the legislature should take responsibility for putting this mess right, not the courts. What is the precedent this bill sets? Because I completely accept what the noble and learned Lord says. It does set a precedent. A precedent that where the court system, because of the exceptional nature of the miscarriage of justice, cannot effectively right the wrong, intervention by the legislature is appropriate. I cannot imagine this precedent ever being repeated. The Irish terrorist cases of the 70s and 80s demeaned and besmirched our court system, but they were put right by a process of appeals. The court system was able to remedy it, and to have intervened by legislation there would have been hugely undermining. The hallmarks of this exception are, first of all, the time it has lasted, 24 years. Second, the need to use bulk hearings suggests the courts cannot deal with it in a normal manner. Third, justice must come soon. And fourth, only legislation provides consistency and clarity. Separation of powers is vital to the rule of law. The courts must be copper-bottomed, protected from interference by the legislature and the executive. But in a constitution based on a parliamentary sovereignty, that separation also involves Parliament and the executive providing necessary support for the courts in funding, in judicial appointments, support in the face of public pressure, not legislating in any way that undermines the rule of law, and very exceptionally legislating where justice cannot be done without it. This legislation is supportive, not undermining. So I support it in principle. I have a number of points on the detail. The first is the decision to exclude from exoneration those cases which would otherwise have, which have already been dealt with by the Court of Appeal. I am strongly against that. I support the noble Lord Arbuthnot and the noble Lord Brown in saying everybody should be exonerated. The fact you got to the Court of Appeal is not a reason for not exonerating you. Those postmasters that got to the Court of Appeal were almost certainly the strongest cases because they got through. They should not be left out in the cold. Second, I would be interested to hear from the Minister what the position in Scotland is. If the Scottish Parliament is willing for one bill to do it, it should be done by one bill. Thirdly, in relation to the DWP cases, I would like to hear why the DWP cases are being separated from everybody else. And it may well be that this House could contribute to this bill by dealing with the Court of Appeal cases, the DWP cases, and maybe streamlining the position with Scotland.
My Lords, I have to admit to being a little nervous as a non-lawyer entering a debate that's already heard from so many distinguished minds. And I see some think they've heard enough from the lawyers and don't need to hear from me. I am grateful to the noble Lord the Minister for introducing this bill. I do concur with other noble lords in hoping it will be very swiftly passed into law. The many victims of this long-running scandal and injustice must now benefit without further undue delay. As the noble Lord the Minister said in opening this debate, Parliament is not the usual route through which we overturn wrongful convictions. I echo others today, as well as what I've said myself in other debates on other matters, in believing that we need to tread very carefully when acting in ways that move us onto territory more normally occupied by the courts and the judiciary. That's particularly important in Britain because we give such huge weight to precedent. Noble Lord the Minister has, I'm pleased to note, assured us that this bill should not be considered a setting of precedent. Others have concurred in that. However, I do think that aspect of what we're doing merits, albeit brief, some deeper consideration. What one government does today, no matter how warily, may be drawn on by future governments in ways that stretch the original intentions well beyond breaking point. Our best defence, perhaps our only defence against that, is to set down very clear principles, not merely general assertions at the outset. And things do happen very differently in different places. American presidents have regularly pardoned political cronies who've committed crimes in their support. I doubt many of us in your Lordship's House will be surprised if a Republican victory later this year resulted in mass pardons even for convicted insurrectionists. Coming closer to home, it's not beyond imagination that far-right movements in Europe, notorious for combining political organisation with street violence, might, should they gain a say in government, seek to overthrow their criminal associates' convictions. Well, let me pick a cause closer to my own heart. Suppose a future coalition government here, needing the support of a minority party more to the left, were told that the price to pay included quashing the convictions of environmental protesters. So, my lords, the question is, how do we in Britain safeguard the rule of law for the long term whilst ensuring the Post Office victims are speedily exonerated? So let me offer briefly 4 simple criteria, ones which I hope in responding to debate the Minister will indicate whether or not he agrees, or indeed has better ones to propose. I'm not at all precious about my suggestions. I am precious about respecting the role and political independence of our judges and courts. I believe this is how we can best avoid future claims of precedent. Firstly, evidence has emerged since those original convictions that sets out so clearly the failings in the Horizon software that had that information, which was known within the Post Office and to Fujitsu at the time, been made available to the defence, it's unimaginable that any jury would have convicted. Indeed, it's doubtful any judge would have allowed a case to proceed that far. For me, this is the most compelling argument for the course of action we're taking today. Our justice system is based solidly on evidence, and where fresh and powerful evidence emerges, we need to be able to take it into account in a timely and effective way. Secondly, I do note the arguments of the noble and learned Lord Bernard of Malden, who reminded us that unless cases are looked at individually, there is indeed a risk that someone who had stolen money might now be let off. However, my lords, the principle that it's better that a guilty person go free than an innocent one be convicted lies at the root of our British justice system. It's enshrined in the requirement that guilt be proven beyond reasonable doubt. Yet it goes back much further. The book of Genesis, and a conversation between Lot and God over the fate of the cities of Sodom and Gomorrah. To save time, I'll leave you to look up that for yourselves. Thirdly, and importantly, we are well clear of partisan political territory here. Whilst I know that we can, in this House and in the other place, proceed to legislate on a simple majority, were there any major grouping in your Lordship's House to feel that this bill contained political bias in any direction, then it would not be safe for us to proceed. Finally, my lords, we're dealing with such a large number of convictions, as so many noble lords have already said, that handling them in any other way would tie up the court system and delay justice both for the Post Office victims and indeed for others in unconnected cases who can't get their matters into court. Hence, my lord, it's that combination. The compelling new evidence, the presumption of innocence, the political neutrality and the sheer number of cases which allow me to offer my support to this bill. I look forward to hearing what other criteria noble lords may adduce. Noble lords, some have already done so in favour of its passing, and indeed the response of the front benches in their winding up speeches.
My lords, I congratulate the government on moving swiftly with this process. This saga has dragged on for 20 years. A trusted public body has been guilty of the most appalling want of care, others might say much worse. I leave that to the judgment and observations of Sir Wyn Williams' inquiry and those of my noble and the views of my noble friend Lord Arbuthnot of Idrham, without whose fantastic work we would not be here today. It's evident now, and I think we must remember this, that individuals pleaded guilty out of fear when offered charges of a lower gravity that offered the chance to avoid imprisonment. Fear in the face of overwhelming evidence, but fatally flawed evidence. That's what induced those pleas. Since then, the courts have in many cases, nonetheless, notwithstanding those guilty pleas, overturned those convictions. That highlights where we are. It is an exceptional and appalling situation. And anyone who's appeared in the past in the Crown Court, as I used to in the first 10 years of my practice, will know what it's like when you tell someone, come on, the evidence is overwhelming. And just occasionally, they don't plead guilty, and very occasionally, you've got an acquittal. That's where we are. That is really important. The Secretary of State for Justice and his ministers have rightly seen it as a priority to go as far and as fast as they can to close this down, to bring justice to these sub-postmasters who've considered so grievously. Speaking as a lawyer, but not so distinguished a lawyer as some of those who've spoken today, I have great admiration for our judges and for legal process. I've thought hard about whether this statutory approach is right. Like others, I've had my misgivings, but I've come to the view that it is undoubtedly the right course. And in saying this, I have the greatest respect for and fully understand the serious and powerful reasons for concern advanced by the former Lord Chief Justice, the noble and learned Lord Burnet. We are right to be concerned about interference by Parliament with the courts. It must not happen. We have lived many happy years, relatively, since the Bill of Rights, and we must continue to do so. These two pillars of our Constitution must remain separate, and we cannot interfere with the courts. But while I say that, we have to accept what has happened here. I'm sure the courts could move fast. The process of renewed appeals would nonetheless be complex. It would take longer than the process we are embarking on here. Quite possibly, some of the deserving sub-postmasters would die before their names were cleared. A pardon does not overturn a conviction. The conviction is still there. Innocent individuals will fall down the cracks if left to ordinary process. Some will simply not come forward. They've had enough of the courts and legal process. They're exhausted. Understandably, they do not want to engage. We have to do everything we can to help them, and we cannot leave others wrongly convicted in these cases. It's clear that the Post Office's own records relating to these prosecutions are lacking. It has the potential to drag on, however hard the judges push, so the knot must be cut. In this sense, I'm happy to adopt what has been said by Dr. Robert Craig, a lecturer in law at the University of Bristol. He has expressed the clear view that the legislation is justified and necessary. The whole process, he says, has been an affront to the conscience of the court. I couldn't put it better myself. So looking forward, I say this. Can I suggest a practical step? And I have another practical one to suggest later, which does not require primary legislation. But I suggest that it's important that once the process set in train by this bill when it becomes statute has been passed, that there is established a website which any individual who wishes to know if they have in fact been cleared by the process or are eligible to be cleared but haven't yet heard, they should be able to log on and request that they be informed where they stand and notify the powers that be of their interest. Publicity must be given to the existence of what is in effect a central clearinghouse to make certain that people whose records may be in a brown folder somewhere are not left unhelped. We know that in the landmark case of Hamilton in 2021, the Court of Appeal quashed the convictions of, I think, 39 sub-postmasters and found their conviction by the Post Office to be an abuse of process and affront to justice. The main issue in those appeals, we know, was the reliability of Horizon. Notwithstanding this, since that decision, 13 cases have been back to the Court of Appeal and have been held to have been safe convictions. So there are still 13 who've been convicted. Now those are the category in Clause 3 who will stand. Their convictions will not be quashed. My noble friend Lord Arbuthnot has expressed profound concerns, which I understand, about those. But the government is in something of a dilemma here, I think, and I understand where it starts from. Nonetheless, Hamilton was in 2021. Since then, much more evidence has come out. Sir Wyn Williams will report within the next year. And it is undoubtedly the case that much evidence will have come to light, which may cast light, a different light, on those 13 convictions. If that is so, then of course those persons can apply to the Criminal Cases Review Commission and ask for their appeals to be reopened. But I suggest a simple practical step. In those 13 cases, the Ministry of Justice should, in the near future, when this bill is passed, personally inform those 13 individuals that they will not be acquitted under the bill, that they are in a different category, but that the inquiry may well have produced new material to justify reopening it. For that purpose, they should be provided with a reasonable sum to enable them to consult solicitors to review the dismissal of their appeal in the light of any fresh evidence which the inquiry or other investigations since 2021 may have brought to light. So I conclude by inviting the government to put in train those two practical measures I have indicated, namely a website to give access to the verification of individuals that they are in fact among those who will stand acquitted as a result of this legislation, and a resource for the 13 who have been convicted and whose appeals have been dismissed since 2021. With that said, I commend this bill and wish it a safe and swift passage.
My Lords, I welcome this bill as it enables some postmasters wrongly convicted to secure some compensation and wipe their slate clean, though the scars of injustice will remain with them and their families forever. I have four broad areas of concern which I would like to raise. Firstly, as has been pointed out, Clause 1 quashes convictions prosecuted by the Post Office and the Crown Prosecution Service only. It does not quash the 61 cases, I believe there are, prosecuted by DWP against postmasters in England and Wales. DWP was the state prosecutor of postmasters until the end of 2012, when the prosecutorial function of the DWP was assigned to the CPS by the Director of Public Prosecutions. So before I go further, I have a question for the Minister, which I'm sure he would answer. Can the Minister say whether any of the CPS prosecutions being quashed were actually initiated by DWP? So further, in my view, the omission of the DWP prosecutions from the bill is utterly unfair. Just like the Post Office and the CPS, the DWP used the Horizon-generated data, and it also faced lies and cover-ups by the Post Office. It has now been conclusively shown that the Post Office and CPS convictions were unsafe because of unreliable evidence, lies and cover-ups. It is hard to know why the the same data, same evidence, same channels of generating evidence are somehow considered to be reliable when it came to prosecutions by DWP. The DWP convictions were mostly prosecuted in the period 2000 to 2006, when there was a very clear conspiracy of silence and cover-up about the flaws in the Horizon system, and there was a lot of information which was actually concealed by the Post Office. Since then, many of the Crown Court transcripts and bundles of evidence relating to those convictions have actually been destroyed. Therefore, the government's argument of investigating on a case-by-case basis is pretty much impossible and is unlikely to provide any fairness to those individuals. The DWP position, as stated in a letter which I have with me, is a letter is signed by a Mrs. Alison Riley, who's a senior lawyer at DWP Legal Advisors in the Government Legal Department. This letter is dated 28 September 2023 and is addressed to a Professor Christopher Hodges of the Horizon Compensation Advisory Board, and it states, I quote, "I can say with some confidence that in the majority of cases we have found that those cases prosecuted by the DWP did not rely on evidence from the Horizon system, but rather relied on physical evidence such as order books, vouchers, and date stamps." End of quote. Now, let us look at the words again. The letter used the phrase, quote, "with some confidence," instead of absolute certainty or 100% confidence. So the letter seems to suggest there is some doubt. It also says, again I quote, has the phrase, "in the majority of cases." So does that mean there were cases where somebody was wrongly prosecuted by relying upon the Horizon-generated data? That is the phrase in the letter. So does this mean that there were some cases where the DWP used Horizon system-generated data to secure some prosecutions? How many cases were they? Which perhaps this letter is not identifying. Hopefully the Minister would be able to tell us. Can the Minister say whether any conviction secured by the DWP has ever been quashed by the courts? Any of them at any time from year 2000 onwards? Has any DWP investigator, official or witness retracted evidence given on oath? If so, that makes all convictions unsafe. Can the Minister categorically say that all 61 cases have been independently reviewed? Which documents were reviewed? When was this done and by whom? Were the victims invited to respond to the review? Has any post-conviction disclosure to postmasters who were previously prosecuted and convicted by proceedings brought by DWP ever made? Were they given the appropriate information? Against a wall of silence and lies by the Post Office, some people convicted by the DWP may even have been denied appeal. But the last 3 years' revelations surely changed that. Can the Minister say how many of those prosecuted by the DWP have actually been denied appeal and perhaps are now deserving of appeal? Just to use the phrase again, I'm reminded of the English jurist William Blackstone's maxim, it is better that 10 guilty persons escape than that one innocent suffer. Therefore, I urge the Minister to amend the bill and quash the convictions of those prosecuted by the DWP. If not, at the very least, he should appoint an inquiry to examine the safety of the DWP convictions. My second point, On 16th January, during the second reading of the Post Office Horizon System Compensation Bill, in this House, I had urged the Minister to remove the Post Office's involvement in setting terms of compensation or administering any aspect of compensation schemes, as that only really multiplies the pain for postmasters. I understand from some postmasters, and one I spoke with earlier today, that the Post Office is still involved with the group litigation order scheme. It is also involved with the Horizon Shortfall Scheme, at least where some 360 to 370 disputed cases are concerned. It is good to know that there is a panel of King's Counsels, lawyers, but the problem is that the Post Office set the terms of reference and guidance and principles of the scheme, and no matter how independent the panel, they are duty-bound to follow those guiding principles. Basically, Post Office cannot be trusted, and its involvement is a source of discomfort. So can the Minister shed some light on why the Post Office is still involved in these schemes and what is to be done to remove it from these things? Thirdly, the Horizon inquiry has provided strong evidence of wrongdoings which warrant criminal charges. However, whenever any question is asked, the Minister's standard response is that we must wait until the end of the Horizon inquiry and the subsequent report before any action is taken. I think that position is deeply unsatisfactory. It is hard to know why prosecutions have not already begun on the basis of evidence which has already been provided to the inquiry. Any delay would mean that many would escape justice altogether. And it is quite conceivable that many will simply say in time they are fragile, they are too old, and they have selective amnesia, and they simply can't remember. Just last Friday, the inquiry took evidence from a Mr. Rob Ismay. He used the phrase, I quote, "I do not know," 125 times. And the phrase, "I cannot remember," at least 40 times. What is going to happen when these individuals are eventually charged, possibly in another 5-6 years? They will simply get away. So I would urge the Minister to begin some criminal inquiries and charges now, not wait until the end of the inquiry. My final fourth point, my Lords, is really the observation that the root cause of the Post Office scandal is the power of giant corporations to bludgeon people into submission and silence, all with a view to boosting profits, executive salaries, and improving the bottom line. That is evident in many other cases. For example, P&O Ferries knowingly flouted the law to sack workers, water companies, rail, energy. They are all abusing people. Then there is Grenfell. Then there is finance industry, a serial offender in mis-selling financial products. Then there are drug companies overcharging the NHS, G4S, Serco overcharging the government for contracts. Yet we haven't really seen any move from the government to democratise corporations, to empower the people and hold this unaccountable power to account. So can the Minister explain when exactly can we expect some reversal, some checks on the corporate power? People at the moment struggle. They can't actually get legal aid to take anybody to court. Regulators are basically in bed with many of the companies, and they are promoting competitiveness rather than safeguarding the customers' interests. Governments themselves are shielding corporate misdeeds. In this House, I have provided evidence of how the government shielded, covered up HSBC's money laundering and made sure that it did not really face the full consequences. So without empowering citizens and curbing corporate power, the Post Office type of scandals would really continue to recur. So can the Minister explain to the House why in all these years, in 14 years, little or nothing has been done to call corporations to account. Thank you.
My Lords, this scandal is rightly recognised as one of the gravest miscarriages of justice in the history of the English legal system. And it seems so obvious now because so much has been reported. But for years, hundreds of sub-postmasters and mistresses were labelled as dishonest and convicted of dishonesty offences when they were telling the truth. One of the most fundamental elements of our justice system is that it's supposed to ensure that innocent people are found innocent, because if innocent people are at risk of being found guilty, then trust in our justice system absolutely disappears. And in that light, exceptional steps are needed to put these injustices right. And although this bill proposes a novel, controversial constitutional innovation, it is being done in aid of the powerless against the powerful, and therefore, in spite of quite strong misgivings, I feel it is justified. To talk about this bill setting a precedent is to overgeneralise the circumstances of the Horizon scandal. We aren't talking about overturning one or two questionable cases. We're talking about rectifying what has been revealed as an industrial enterprise to maliciously prosecute hundreds of innocent people. Now, Lord Falconer did make, the noble and learned Lord Falconer did make the point about all should be exonerated, and I think that's absolutely right. It is not enough to create, again, two tiers of those people who are so badly treated. If such a whole-scale injustice does take place again, then victims and the wider public can be assured that Parliament will intervene on behalf of the powerlessness against the powerful to secure justice. But let's all hope that this is the first and last time that this unprecedented legislation is ever justified. But to have real justice, there is a sort of grey cloud hanging over this bill, and that is that we have to have Fujitsu's role thoroughly investigated and prosecutions to start happening. As the noble Lord Sicker says, it is wrong that we have to wait until the end of the inquiry, because we know already that Fujitsu was guilty of many, many infractions. They were aware of the problems from the start. They were obviously aware of their employees having remote access. And in 2009, Computer Weekly made them aware of the link between the glitches in the Horizon system and the prosecution of sub-postmasters. Now, the chief executive of Fujitsu at the time, Roger Gilbert, said Computer Weekly wasn't a publication he subscribed to. So clearly, he couldn't know anything about it. His press office really were scandalously lax. And Fujitsu are still a major government contractor who give money to the Conservative Party. Fujitsu have numerous other government contracts, and the government have, for ideological reasons, been outsourcing all their IT expertise exactly the same as the Post Office do. And the next government need to reverse this process, take that IT expertise back in-house, or at least employ enough in-house expertise to know when a company is getting it wrong or hiding the truth, or providing a service that is a complete liability or security risk. If you let major corporations run your government, then taxpayers are going to be ripped off and find that they are paying up millions when things go wrong. So, two final points. Fujitsu should be in the dock. Prosecution should have begun already. And secondly, Fujitsu should be paying the costs of the money paid back to sub-postmasters and mistresses, and not us taxpayers.
Yeah.
My Lords, the Horizon scandal was described in the explanatory notes as, and I quote, a miscarriage of justice of unparalleled scale and impact. I do not know of anyone who would challenge this description. I certainly would not. It has had a devastating impact over a long period on huge numbers of sub-postmasters, leading to shattered lives, including huge trauma and mental distress, suicides, financial and reputational ruin, and the loss of a normal, happy retirement. The sub-postmasters, who have waited for far too long for recognition of their suffering and of the injustice which has overwhelmed their lives, deserve a speedy and simple route to bring that suffering and injustice to an end. The question for this House is whether this bill is in all respects appropriate to achieve that goal. The difficulty which we must confront head-on is that the bill infringes one of the most fundamental and critical tenets of our Constitution, the independence of the judiciary being one of the three pillars of our Constitution, the executive, parliament and the judiciary. Each of those pillars has its allotted function, providing the checks and balances essential for a democratic state. Increasingly, in our own state, there has been a blurring of lines between the executive and parliament. Noble Lord the Minister, in his opening address, said that it is really Parliament and not the executive which should be regarded as the body responsible for the legislative en masse acquittals provided for in the bill. The reality, however, is that the executive, especially one with a significant majority in the other place, almost always secures the implementation of its policies and elective dictatorship, as it has been called. Reducing the bill to its essence, the executive is using Parliament to strip the judiciary of one of its central functions, determining who is guilty and who is not guilty of a criminal offence. That intrusion into the judicial pillar of the state is made as plain as could be from the wording of Clause 6, subclause 1 of the bill, which states that a person whose conviction is quashed by Section 1, subsection 1, and I quote, is to be treated as if, on the coming into force of this Act, the conviction had been quashed by a court on an appeal. End of the quote. It is a characteristic of every autocracy and dictatorship that the executive directly or indirectly nullifies one or more aspects of judicial independence. History has demonstrated that there can be no liberty without judicial independence. This may seem a long way from the benign bill which we are now debating, but it is not. We must guard our basic constitutional norms ferociously. Perhaps the most important duty of this House performs its essential role as a check and balance in the lawmaking process is to do precisely that when it is faced with draft legislation which is more the result of political expediency than constitutional compliance. Paragraph 24 of the explanatory notes and the Noble Lord the Minister states that the bill does not set any constitutional precedent. That, however, is a quite meaningless statement. Of course, the bill does not set any constitutional precedent, since no parliament can bind a future parliament. Each one is sovereign. But by contrast, the bill, if enacted, will of course provide an historical example of an overreach by the executive through Parliament into the judicial pillar of the state. In that sense, it is indeed a precedent for any government with a sufficient parliamentary majority, even where the object of the government is not a benign one. Lord Faulkner, the noble and learned Lord Faulkner of Thoroton, suggested that the precedent was a very narrow one, effectively confining it to the precise facts and circumstances of the present scandal. But I see no reason at all why a non-benign executive should not take the wider view that I have just described. The precedent is all the more egregious because, contrary to the impression created by the explanatory notes, it is not at all clear that the bill is necessary to achieve the desired objective. The noble and learned Lord Burnet of Malden has described several practical arguments as to why our constitutional norms can be preserved while delivering the justice that the postmasters so urgently require. I wish to make just one or 2 points in relation to this. Dame Sue Carr, the Lady Chief Justice of England and Wales, appeared before the Justice Committee of the other place on the 16th of January early this year and addressed the committee on the announcement of the Prime Minister the previous week that there would be emergency legislation to quash en masse the convictions of people prosecuted by the Post Office on the basis of Horizon data. The Chief Justice refuted any suggestion that the judiciary had given the proposed legislation the green light. She said that she had had 2 short conversations with the Justice Secretary at his urgent request, and that was the extent of the consultation that had taken place. She also refuted any suggestion that the courts had been unable to cope with the cases or would be unable to cope with future volumes. Where do we find anywhere, whether in the explanatory notes or elsewhere, any analysis by the government of why the courts would be unable to make special arrangements for expedited appeals in relation to all convictions, or as to how quickly that could be done? The noble and learned Lord Falkner gave a range of speculative difficulties that might arise in relation, or would arise, in relation to a wide variety of matters. He said and acknowledged, as I understand what he said, that it might be possible to provide alternative arrangements that would satisfy the giving of justice in a speedy and effective way, but that this would result in bending our justice system out of balance. But all of this is a balance. It is better, I would suggest, to bend the justice system out of its ordinary shape, if this can be done, as I think it can be, if that would make giving proper and fair and speedy restitution and acquittals to the postmasters, rather than drive a coach and horses through one of our most important and fundamental constitutional norms. The second point that I wish to emphasize in relation to the various examples given by the noble and learned Lord Falkner of Thoroton is that, as I've mentioned, his examples and his of difficulties and his expansion on the problems are all speculative. There has been, so far as I'm aware, no proper discussion between the executive and the senior judiciary as to what it might be possible to achieve. The truth of the matter is that every problem said to make the bill a necessity is capable of resolution without legislative en masse acquittals, including speed of appeals, reluctance of those convicted to become further involved in our court proceedings, lack of evidence, and the test for a successful appeal against conviction. I do not accept that these matters are impossible of achievement outside the context of the present bill. What we need is evidence of actual discussions as to what is viable, rather than deal with speculation as to what may or may not occur. And for my part, in the absence of any clear and public explanation by the government, following discussions with the senior judiciary, for the reasons I've given, I do not consider it would be right to support the legislative approach of acquitting all of those who have been convicted through this legislation.
My Lords, this has been a sober and serious second reading, understandably so. How does one even begin to find the words to describe such an unspeakable set of circumstances? Perhaps to pull on those who have been faced with many miscarriages of justice, the CCRC themselves describing this as the most widespread miscarriage of justice they have seen. It is at least for that reason that I support this legislation. I'm well aware and completely supportive of the separation of powers and the fine and delicate balance of our unwritten constitution. But in passing this legislation, it's as clear as it can be that Parliament will be carrying out the will of the people. It's also clear that this will set a precedent. I'm delicately untroubled by that, because it sets a precedent for a set of circumstances that, were they to occur again, it may well be the case that the will of the people and Parliament need to step in. And I think it is those set of circumstances which delicately and with respect argue against the claims that this tends to autocracy, tends towards totalitarianism. It isn't something that any of us are undertaking lightly, but it is a means of securing justice for those who have waited far too long, many serving prison sentences, all of them serving sentences of being convicted and carrying that often for many for decades. This is why I believe Parliament is right to take this bill through, to enable justice in the most timely manner in the position that we are in now. It's difficult to even call it timely, bearing in mind how long this has already taken. But to ensure justice and equity for all those who have suffered for so long, I need to ask my noble friend the Minister, how can the government act to ensure that justice for all happens on a similar, if not identical, timeline? How can we, whilst understanding the reserved nature of the Post Office and the devolved nature of justice, how can the government work even more with the Scottish Parliament to ensure that for all postmistresses and postmasters in Scotland can achieve justice at the same or similar time frame to those in England, Wales and Northern Ireland? Similarly, as other noble lords have rightly stated, it seems inequitable for those who have already been to the Court of Appeal to be excluded from this legislation. They're effectively being punished for having been able to pursue their claims quickly and effectively only to find themselves receiving no remedy and the outcome that the court at that stage on the evidence provided delivered for them. My Lords, we know that equity, that justice delayed is justice denied. We have the opportunity to at least bring justice through the legislative process, yes, novel, yes, unprecedented, through this bill. Turning to the means by which the private prosecutions were brought about in the first place, Section 6.1 of the Prosecution of Offenders Act 1985, many members of the public were shocked to discover that the Post Office could pursue such prosecutions in this manner. Shocked even more so when they realised that this was a power in no sense just available to the Post Office, available across the piece. The Post Office effectively acting as investigator, prosecutor in cases where they were the alleged victim. Wouldn't my noble friend the Minister agree that this is self-evidently prima facie problematic? If we are to deliver justice for all those who have suffered, even with this bill, can I ask my noble friend, how many sub-postmistresses and masters will be left with their convictions unquashed after the passing of this legislation? It's clear, as much as we can be on the numbers, that there's approaching 1,000 convictions. So far, around about, again, as much as we can know, 103 quashings of convictions, 10%. This bill, when it comes into statute, will certainly address a large number of those convictions. But how many people, in the Minister's best knowledge on the evidence he has available to him, will still be left unhelped after we pass this legislation? My Lords, without moving away from the incredibly serious matter of today, I'd like to ask my noble friend the Minister what thoughts the government have put to reflecting on Section 6.1 of the Prosecution of Offenders Act 1985. What are the safeguards? How did they work in these instances? Are the government satisfied to continue with this legislation in its current form? Are the Law Commission looking into this? Similarly, looking to a potential future beyond this unprecedented set of circumstances, what are the government's thoughts in terms of the future of the Post Office? It's an entity unique. It's been in our communities, on most of our high streets, for over half a millennia. But 500 years plus of history doesn't give any organisation any right to necessarily continue in any form. Will my noble friend the Minister agree that urgent thought in terms of the structure of the Post Office, potentially looking at mutualisation or other such models, could at least, once we're through all of this, enable a brighter, better Post Office with the postmistresses and postmasters, pillars of our community? Knowing our communities, knowing the business better than anybody else, wouldn't it make sense to have their voices, past and present postmistresses and postmasters, involved in shaping that future? In equalities discussions, there's a very useful mantra: nothing about us without us. I would ever so gently suggest that that mantra should well apply to considerations of the Post Office going forward, where the voices of all of those sub-postmasters and mistresses right across our country are able to have a voice in shaping what needs to be a very different future for our Post Office.
My Lords, my comments are from, as we say in politics, from the grassroots. What some postmasters are saying and their feelings. And as for the legal matters of this case, I leave it to your Lordship's great legal minds. My Lords, I wholeheartedly support this bill. It is long overdue, and sooner we get it on the statutory books, the better. The sub-postmasters have suffered long enough. Sooner we close this shameful chapter in our post office history, the better. This bill must give faith to all those who have lost theirs in our justice system and in the post office management. Most important of all, I hope the end result of this bill will satisfy all the sub-postmasters, and then they are properly compensated for their sufferings. I fully support the blanket squashing of their conviction or any other wrongdoing they are accused of, wherever the post office had acted as judge, jury, and the executioner. My Lords, let me make it quite plain right from the outset that my heart goes out to each and every one of the victims of this scandal, whatever their background, whichever community they belong to. This is one of the greatest miscarriage of justice in the history of our country. Although all sub-postmasters were treated badly, but some were subjected to extra layer of suffering. I would like to bring to your attention, in particular, the victims who were from the Asian heritage or the background. Although my concerns are equally applicable to those from the African Caribbean background as well. This issue was particularly reported in the Newsnight around Christmas time by Seema Katasha, one of the journalists. According to a post office survey in 2012, over 40% of the sub-postmasters in UK are from the Asian background. But personally, I think it could be more than that. They not only run the post office in the inner cities where there are large ethnic minority population, but also in small villages up and down the country. When the news of this miscarriage of justice began to break over 20 years ago in a local and on social media, these Asian sub-postmasters were the hardest hit. Firstly, it was alleged that the post office official who were investigating them treated them with racial malice and disdain. And some comments such as, and I quote, and these comments are in public domain, and I quote, "All you foreigners are the same, money grabbers, stealing money from the post office and sending it to your own country," unquote. And they were often spoken to in a condescending language, in a different tone, it was reported. Secondly, my Lords, the shame in the Indian community, Asian community, and the family reputation. Every culture and every society is perceptive to social shame, but because of the closeness of the Asian society, it is more keenly felt by them. And you've got to be an Asian to understand it, my Lords, and of a certain age, like myself. Some of these Asians came to UK with nothing, and out of their sheer hard work, they built a comfortable lifestyle for them and for their families. It is a well-known fact that some Asian works hard for themselves, not for themselves, but to leave something behind for their children, so that they wouldn't have to go through all the same problems again. And when they are falsely accused of being thieves in the community, my Lords, that is the deepest cut of them all. They try to hide not just from their community, but from themselves as well. And worst of all, what their children and their grandchildren think of them. No wonder
some of these sub-postmasters suffered mental breakdown and tried to commit suicide. Take the case of Just Kaur from the West Midlands and the ordeal the post office put her through. I have spoken with her a number of times. She had 14 electric shock treatments. And when she was in a hospital for the treatment, the post office did not believe her. So they actually sent their own doctor to verify her condition. How low can you get? We all pray to God that Jess will recover from her terrible ordeal soon. Another Asian lady, Rabina Shahnan from Shropshire, my home county, lost everything, her business, her home, and was forced to live in a van on the streets of Shrewsbury. And she said she felt suicidal. Another Asian lady from London, Seema Misra, was sent to jail while she was pregnant. And Mrs. Kashmir Kaur Gill from Oxford was prosecuted in 2009 for false accounting and was given 5 years of suspended sentence. She and her family's reputation was destroyed in the community and suffered decades of hell and developed mental health problem. I could go on and on with these examples. With regards to the Asian suffering, I don't think the ITV drama, the famous one we all know, even scratched the surface of this particular race and cultural issue. I hope this bill will acknowledge these particular issues. Again, my lords, as I have said at the beginning, my heart goes out to all the sub-postmasters, irrespective of their background. And finally, and this is my personal view, all the post office, senior managers, directors, chief executives, solicitors, software company managers, directors, and all who went above and beyond the call of their duty to protect the post office brand and their jobs and did not care about the human suffering, and all those who have been giving evidence to Sir William's inquiry or to the Parliament, they have all apologised. Apologies, my lords, are just words in the wind, and there should be some kind of a financial sanction on them, and that I leave it to your lordships. Thank you very much for letting me make this comment.
Speaking back up before we start. Okay, my lords, I wasn't intending to speak, but Lord Faulkner and the noble lord here, I think, posed for me a conundrum. And by the way, I live on the village where the conundrum road is, right near the Scottish border. When you face a conundrum, what do? First of all, I want to support this bill, but I have a problem. It is the issue that Lord Faulkner was raising about the 13 whose appeals were turned down. Now, if you include them in this bill, you'll be directly interfering in the Court of Appeal. That's exactly what you'll be doing. You're saying, we do not agree with what you did, so we are pardoning these people. My suggestion is the minister and the government need to go back and find some other lawyers in light of the evidence which we've been hearing in the inquiry, whether there is still fresh evidence that can emerge so that those 13 can go back to the Court of Appeal. Because my worry is, if you legislate en bloc, as was being suggested, you run the danger that this time you are definitely interfering and telling the Court of Appeal that their decision was not the right one. So that needs resolving, because if you don't resolve it for the likes of me, I find myself in a conundrum. Secondly, the Department of Work and Pensions. Why are those also not requiring the same examination like all other convictions? And somebody somewhere has got to bend their mind to those 61 Because if you don't do it, you're giving the impression that they had better evidence, because the people have not appealed, therefore it's not going to be followed. So for me, this bill should not have a say about what the decision of the Court of Appeal was, those 13 cases. And the Department of Work and Pensions, again, I want to suggest that somebody needs to look afresh at those 61 and whether there is a possibility, not by this bill, for fresh hearing by the Court of Appeal.
It's an honour to follow so many noble lords in speaking in this second reading. And from these benches, we too support the bill. And I'm grateful that the Right Reverend Prelate pointed out that there is not one single party grouping or other grouping against it. And that speaks to the highly unusual circumstances. And whilst I'm sure it will not entirely comfort the noble and learned Lords Burnett and Etherton, I hope that it will give them some reassurance that it is meeting the issues that they raised, both of them, about the potential for future totalitarian moves. There really is a clear, and it was true actually, if you read the progress of this bill in another place, exactly the same happened there. There was much thought about the difficulties of the Constitution and how this fits in, whilst trying to balance that with the really difficult circumstances that this country faces itself in following this extraordinary miscarriage of justice. I want to thank the Noble Lord the Minister for the meeting last week, and also to the Lord's Library and to the Law Society for their very helpful briefings. And I'm speaking from these benches today in the absence of my noble friend Lord Fox, who hopes to be able to join us for the next stage of the bill. My Lords, for those of us who have perhaps been sad enough to sit and watch many of the hours of evidence in this phase of the inquiry, it really is vital to remember the lives of the sub-postmasters and other Post Office frontline staff whose lives have been ruined by Post Office Limited and Fujitsu, both of whom convinced magistrates, juries and judges that the software package could not be accessed remotely. And as Lord Arbuthnot outlined, and Lady Jones also spoke about, the day Fujitsu will need to face justice, so will the management at Post Office Limited, and not just Fujitsu, because evidence in recent weeks is now putting into the public domain that staff at both organisations knew many, many years ago that it was possible to access Horizon remotely, and that it was also done to remedy glitches and errors. Lord Sicker referred to the oral evidence of Rod Ismay as being unimpressive. Helpfully, though, the written evidence presented to him of emails and reports over the time period made it absolutely plain who knew what when. Despite that, since the year 2000, Post Office has prosecutors, as we've heard, somewhere over 730 individuals, many of whom were convicted and imprisoned on what appears to be false evidence and assertions. Many were not only bankrupted, they lost their homes, their businesses, and the faith of their local communities, as Lord Saha so rightly pointed out, when they served in their local post office branch. And as we've heard, some postmasters committed suicide. Now, as with other scandals, my lords, like the infected blood victims, compensation and interim compensation schemes have been set up. But those with convictions not yet quashed are ineligible to apply for them. The Horizon Compensatory Advisory Board has made a specific recommendation that all the affected sub-postmasters' convictions are unsafe and should be swiftly overturned. And my lords, as I've already outlined, what we're hearing in the inquiry just reinforces that point beyond any shadow of doubt. We must leave it to Sir Wyn Williams to present his inquiry report and his findings in due course. But it is evident that things have gone badly wrong. Lord Brown of Ladyton reminded me of the software engineer's description of error-filled software. I'm married to an engineer who's involved with software. Common phrase in our family is garbage in, garbage out. Yet one of the problems of this case is that everybody believed the software was absolutely invincible. Everybody. And therein lay the miscarriage of justice. It is public knowledge, both through the Court of Appeal judgment in 2021 and through the evidence given under oath at the public inquiry, that the technical reasons for every single prosecution relied on was that it was impossible for anyone, apart from the sub-postmaster, to access an individual's account. We know, my lords, that is demonstrably untrue. And worse, POL and Fujitsu continued to rely on it even when they knew it was not the case. My lord, that is an even worse miscarriage of justice. On these grounds alone, every single one of the remaining Horizon convictions should be overturned. I'm grateful to the noble and learned Lord Burnett saying that the judiciary could and should be able to proceed with appeals. But there are real concerns, my lords, about capacity, as Lord Faulkner spoke about, and Lord Sandhurst expressed concerns about the timescale too. We know there are many backlogs in cases coming to the Criminal Cases Review Board, let alone finding time in the Court of Appeal. And I think, my lords, the one thing that we've heard from every speaker today is that these issues must be resolved at pace. Some convicted postmasters are dying. Other are in their retirement age, having lost everything decades ago as a result of these convictions. It's not just unfair that they cannot access justice swiftly, it is itself an injustice. And I support Lord Arbuthnot's concerns about DWP convictions between the year 2000 and 2006 being treated differently to CPS convictions. So will the Minister ensure that DWP is required now to assess its prosecutions in this case? And I'm very grateful to Lord Sicker for going into further detail on the DWP convictions being reliable. And I think, given that Post Office Limited have now given up their right to conduct prosecutions, I'm wondering if the same should also be true for DWP. My lords, I have some questions for the Minister, which I did warn him about last week. The first is that in Clause 2, the relevant offence is defined by time between 1996 and 2018, by offence, and at 2.6 specifically mentioning the Horizon system, as does Clause 10. And Clause 8 provides power for the Secretary of State to make further consequential provision. The Delegated Powers Supplementary Memorandum confirms the narrow scope, and all of this should give reassurance to your Lordship's House that that is true. However, my Lords, there is a problem in that the system prior to Horizon, Capture, is now being revealed to have had serious software glitches and errors in the same way. And I am very grateful that this government has now instituted an inquiry to follow in the same way, hopefully of a more limited nature. And the independent newspaper reported that former sub-postmasters had claimed they'd suffered unexplained shortfalls caused by Capture, which was rolled out in the early 1990s. Details show that Post Office knew that Capture was prone to faults and glitches, and yet prosecutions went ahead, my lords. So can I ask the noble Lord the Minister that in the event following the inquiry that the government's now instigated into the Capture convictions, first of all, would it be possible, I suspect the answer is not, to add Capture to the Horizon inquiry? Yes, the software definitely predated Horizon, but everything else, including the bizarre and unexpected shortfalls, the way that Royal Mail conducted the prosecutions, including repeated assertions, is very, very similar to the Horizon case. If that is not possible, and if the Capture inquiry comes to the same conclusions as is now evident from the Horizon inquiry, what route to redress is available for the Capture postmasters? My lords, Lord Arbuthnot and Lord Sandhurst and Lord Sentamu all spoke of the 13 people post the Hamilton case that had their sentences upheld by the Court of Appeal, of which 7 are entitled to appeal but 6 were refused leave to appeal. Assuming that the final inquiry report confirms that cases relating to Horizon should never have been brought to court at all because of Post Office relying in every case on Horizon, and it was then saying repeatedly it was not possible for anyone to be able to access a Postmaster Horizon's account, can the Secretary of State ensure that these cases are entitled to make an application to appeal? Because there are consequential rights, they are limited in scope, the bill says, for the Secretary of State to do so. But would a particular finding from the inquiry be something that could happen? So can I ask, and Lord Sandhurst said he believed that those people would not be able to get any their convictions overturned under this bill. So can I ask, is that true? He's shaking his head, and if I misunderstood him, my apologies. But would the power of the Secretary of State be able to be used in regulation as it relates to Horizon? My Lords, I hope that we will be able to progress with the same carefulness that we've started this
It's clause 3(2) of the bill. You don't get your conviction allowed if it's been dismissed by the Court of Appeal.
My Lords, I was referring to clause 8, which is the power of the Secretary of State to make further consequential provision. And I wondered if the recommendations and report from the Horizon inquiry might be able to be used by a Secretary of State to make that happen. I think at this moment I will pause.
My Lords, I'd like to begin by thanking the Noble Lord the Minister and the departmental team for their work on this bill and for being available to meet with myself, Lord Leong, and others from across the House. In reading back over some of my speeches, and I'm just a newbie to this, but from 2019, 20 and 21, one theme shines through, and that's the sheer injustice of this. The Post Office Limited and Fujitsu scandal. And I use the words Post Office and Fujitsu rather than Horizon. Horizon is just a faceless IT system. Yes, the Post Office Limited is culpable, senior management to blame, the board's negligent, the department and their representatives missing. And there are two main parties to this, Fujitsu and Post Office Limited. And I'm sure that we will come back to the board, the individuals, the non-execs and the department representatives, as Lord Forsyth has raised many times in previous debates. Naturally, I'd like to pay tribute to those many sub-postmasters and mistresses who've campaigned tirelessly for justice. Their resolve in the face of unimaginable levels of abuse and suffering is testament to their courage. It was their stories that galvanised the country behind taking the urgent and unprecedented action in this bill. And though it may have been a television drama that finally ignited public consciousness on this issue, I also want to reiterate the tributes to Lord Arbuthnot and to Kevin Jones MP for their years of work in and outside of Parliament to lay bare the great injustices and the fight of the sub-postmasters and mistresses. And this is not an academic debate. This is fundamentally about people's lives. And I'm not a lawyer, but I do understand the focus on legal precedents, on the debate around the judiciary and the executive and Parliament, the inference on our constitution, the independence of the judiciary. But this is about people, and that's the balance that this House needs to reach. I made a speech in 2020 and in response to the court case, Bates v the Post Office, which was settled in 2019. And I mentioned a number of individual cases. Lord Sahota has touched on two of those, but it is just worth putting into record what actually happened to those individuals. There was Seema Misra, who ran a post office with her husband in Surrey, but time and again had to put her own money into the till. Shortfall of £80,000 was ultimately found, and she was sentenced to 15 months in jail while pregnant with her second child. And then there was Rabina Shaheen, who was jailed for 12 months in 2010 after she was accused of stealing over £40,000 at the Grenfields Post Office in Shrewsbury. And we all know Joe Hamilton's story. Joe was accused of taking £36,000 from a village shop she ran in Hampshire. After pleading guilty to false accounting to avoid a more serious charge, she gave up her shop and found it difficult to get a new job due to her criminal record. So during today's debate, we must not lose sight of the impact of the failures on these families. This is an important bill, and those of us on these benches support it wholeheartedly. Labour committed itself to working with the government to ensuring the best possible outcome for victims. And I'm glad that the government agrees with us that these wrongful convictions ought to be quashed and that compensation needs to be delivered urgently. I'm particularly encouraged by the noble Lord the Minister's desire to see convictions overturned prior to the summer recess. I think that deals with a number of the legal arguments about other options. If we did follow those, the overturning of convictions would not happen before the summer recess. And I'm glad to see that the government has worked constructively with members of the other place to expand the terms to include Northern Irish sub-postmasters in the bill before us today. It is our hope that the Scottish Parliament also soon passes a similar bill, as Lord Brown touched on in his opening remarks, so that victims all across the UK can benefit from having their convictions overturned. This is one of the most egregious miscarriages of justice in British legal history, and I'm heartened to see that people from across all parties and none working together to deliver justice for those innocent people who have served at the heart of our communities. The many stories we've heard across this debate in this House and the other place never fail to shock me, and the emphasis, the sheer scale of the scuffering that this scandal has caused. Now, Lord Arbuthnot touched on Justice Fraser in his remarks in 2019. And again, we've come a long way since 2019, but we haven't come that far. And it's worth reminding ourselves. And I was very struck by the vivid language that Justice Fraser used in his judgment, stating that Post Office Limited showed, his words, the most dreadful complacency and total lack of interest in investigating these serious issues, of which amounted to, and I quote, the 21st century equivalent of maintaining that the earth is flat. Justice Fraser concluded that sub-postmasters were treated in capricious and arbitrary ways which would not be unfamiliar to a mid-Victorian factory owner. It does beg the question, though, how did our judicial system allow so many sub-postmasters and mistresses to be found guilty over so many years. It is deeply shameful that justice did not come quick enough for those sub-postmasters who died or killed themselves before we could find redress. We want now to see justice for all victims. And to end, I would like to ask, I think I've actually got a little bit more to do, so maybe that came a little bit early. I'd like to ask the Noble Lord the Minister how confident he is, and this has been a theme across the debate, how confident he is in the identifying criteria, and whether he can assure the House that all those affected are included in it. It is important, I feel, that we recognise the impact on sub-postmasters' families, as the Last Chance for Children of Sub-Postmasters campaign group have highlighted. I also look forward to the publication of Wyn Williams' inquiry report, as it will give an important opportunity to reflect more broadly on how we may be able to resolve further issues in a timely and dignified manner. It will be vital for the legal system and the government, as well as corporate bodies, to learn the lessons of these cases. As I said in the debate on this issue in January, we need to see cultural change and to see an end to the constant stream of scandal after scandal, the destruction of people's lives, the cover-up, the vindictive way in which victims were treated once they came forward, the lethargic way in which justice is served, the culture of not being held responsible for failure and instead even being rewarded. That must all end, and it remains my hope that this brings about a serious shift in the way those in positions of power are permitted to act. I'm glad that the bill can give sub-postmasters and mistresses some relief, some dignity, and official acknowledgement of their innocence. It is important, however, to note that this is an exceptional bill and an isolated case. The House's agreement on this bill must never be misconstrued as any kind of desire to set a precedent. The independence of the judiciary must be upheld. I welcome the government's reassurances on this particular concern, but I would ask for more. Would the Noble Lord the Minister not consider a more explicit element on the face of the bill? In addition, I would also like to ask the Noble Lord the Minister to elaborate, and it's been touched on by a number of noble lords and baronesses this evening, to touch on the decision to include CPS prosecutions but not DWP or the 13 Court of Appeal cases, as outlined by Lord Arbuthnot. We on these benches welcome this vital piece of legislation, but of course this is not the end. There is more to be done to right the wrongs. The bill before us is just and is a positive step on the road to justice for victims. It may not be the final destination, but it is nevertheless an important milestone. So I think I would just finish with Lord Arbuthnot's words, which I think are a great subtitle for this bill. The price we pay for the exoneration of the innocent are fine words.
Hear, hear. Hear, hear.
My Lords, this has been a thoughtful and considered debate, and I'm very grateful for the broad and insightful contributions from noble lords across the whole of your Lordship's House. And I was particularly grateful for the opening contributions from their noble and learned lords, both Lord Falconer Thoroton and Lord Burnett of Malden, one speaking as a former Lord Chancellor, other speaking as a former Lord Chief Justice, and able to frame so eloquently the two potential solutions available to your Lordship's House to basically right these wrongs. The government acknowledges that the quashing of convictions by an Act of Parliament is an exceptional step. But we believe it is one required to respond to a factually exceptional situation. We know that many postmasters are simply too traumatised or disenchanted with authority to consider appealing. No matter how easy we make it, they want to see no further lawyer, no further court. They are scunnered. In many cases, in fact, evidence simply no longer exists anyway in order to help their case. The scale and circumstances of prosecutorial and investigative misconduct over such an extended period are also unique in our history. Indeed, this scale of this miscarriage of justice is an affront to the rule of law itself. It is right, therefore, that the government intervenes to deliver justice to hundreds of postmasters who deserve this without having to make a huge amount of effort themselves. We need to do this whilst respecting the delicate constitutional balance so eloquently put forward by a number of the noble and learned lords this afternoon. If we just could start there at the legislative approach that we're taking to cover that right up front. I understand the concerns of noble and learned lords, Lord Burnet of Malden and Lord Etherton, and the right relevant prelate, the Bishop of Manchester. We all share their respect for an independent judiciary. I've been clear that the bill is not a comment on the outstanding work of the courts and judiciary, who have dealt swiftly with the cases before them, and cognizant of the assurances given by the judiciary that they would move fast in this case. But I respectfully disagree with the noble and learned Lord Etherton's characterisation of the legislation. We agree that the separation of powers is a vital part of our justice system, but public confidence and faith in the system is also vital. This is a miscarriage of justice on a scale never seen before, and the circumstances are exceptional. We have considered carefully other approaches, including court processes. However, ultimately, no reform short of this legislative approach provides the swift remedy needed as a result of these unprecedented circumstances. Many postmasters would not see justice through the courts because much of the evidence about individual cases has now been destroyed, or because many postmasters no longer trust the criminal justice system and therefore will not come forward. It is therefore right that the government takes action to put this right. The noble and learned Lord Burnet of Malden raised the possibility of legislating to give ministers powers to refer cases to the Court of Appeal and assume all convictions were wrongful unless new evidence is presented. Reconsideration of cases by the Court of Appeal would take time, even if court processes were expedited. Further, a presumption that all relevant convictions are unsafe is rebuttable, and we cannot be sure that every case would pass through the courts swiftly and without adjournments. This approach would not avoid interfering with the independence of the judiciary. It would raise other constitutional concerns, as it would make an assumption about the outcome of the cases being referred, meaning the government was still interfering in the judicial process of the senior appellate court. Noble and learned Lord Barnett also spoke about comments made by the Lady Chief Justice, where she said that in over 90% of cases the defendants had pleaded guilty. We're not able to verify this figure, which itself tells the noble lawyers quite a lot about this case. As the noble and learned Lord Faulkner rightly raised, we're also aware from Sir Wynne Williams' inquiry of evidence suggests that individuals pleaded guilty because they were told to or felt under pressure. Turning to the specific issue of the Court of Appeal cases, which was highlighted again at the beginning of this debate by noble Lord Arbuthnot of Idrum, and again raised by noble learned Lord Faulkner and indeed Lord Holmes of Richmond. This is a difficult issue. I'd like to thank the Noble Lords for raising this, because let's start by reminding the Lordship's House of the unprecedented and constitutionally sensitive nature of this legislation. That is why it is vital we legislate in a way which respects the separation of powers and the independence of the judiciary as far as possible. Including convictions that have been upheld by the Court of Appeal would override decisions taken by the senior judiciary. Of the 13 such cases that we know of, 7 were upheld by the Court of Appeal and 6 were refused leave to appeal. They're excluded from the bill because the government believes that we should tread very carefully where judges in the senior appellate courts have considered a case on its merits. We recognise that this approach may leave a small number of individuals concerned about the way forward for their cases. In cases where the Court of Appeal has upheld a conviction, the usual routes of appeal remain available to them. If I can turn now to the matter of the DWP cases, of which there are...
I'm sure that's right for the 7 who could appeal, but there were 6 who were not given leave to appeal. What would their route be to getting justice?
My understanding is that 6 were given no right to appeal because they considered they didn't have the evidence to allow them to do so. So they're effectively considered in the 13 whose convictions were not overturned. And therefore they're included within the same category.
I've been focusing on the recent trips to the Court of Appeal. I don't know whether there were trips to the Court of Appeal in the immediate aftermath of the convictions that started in 1996 and going forward. Are we only talking about recent trips to the Court of Appeal, or does it include trips to the Court of Appeal that might have been a decade ago before the nature of the scandal was known?
I will cross-check the record, but my understanding is these 13 are recent and came to Court of Appeal post the Hamilton judgment. So therefore the courts were aware of that, of the background in that case. Turning to the DWP cases, the Noble Lords Lord Arbuthnot of Idrum and Noble and Learned Lord Faulkner of Thoroton and Lord Sika and Lord McNichol have all questioned why this legislation does not include cases prosecuted by DWP, which we believe amount to 62 cases. Regarding Noble Lord Sika's question about whether any DWP prosecuted cases were quashed, I can confirm we're not aware of any convictions being quashed by the appeal court. These cases, unlike many of the cases prosecuted by the Post Office or CPS, involved wider corroborating evidence beyond that supplied by the faulty Horizon system, so are unlikely to be unsafe in the same way. The existing and established appeal processes remain available in relation to those cases. Turning to financial redress, I agree wholeheartedly with Noble Lords Lord Sika and Lord Holmes of Richmond about the importance of delivering financial redress as quickly as possible. And I'm pleased to say that as of 30th of April, we have paid out more than 200 million in redress to over 2,800 claimants. And in fact, if you take the main scheme, being the Horizon Shortfall Scheme, 88% of claims have now been received and 72% have been paid out. And the government is going as fast as we can go. We are reliant on the appeals coming forward and the claimants making their claims. And we expect at the moment that many of those, especially those overturned convictions, are waiting for this bill to pass, and we would expect their claims to come in more quickly following this legislation. Financial redress clearly is not in the scope of this particular legislation. However, I do hope it will reassure the Noble Lords that once the necessary legislation has been passed, we will provide a route to full, fair and rapid financial redress for quashed convictions. We will include information about redress in the notifications which we send to postmasters when their convictions are overturned. Our aim is that the redress process will follow seamlessly from the process of overturning convictions. As my colleague Minister Holling-Rake said in the other place,
I thank the Minister for giving way. Before we leave the issue of DWP convictions behind, can he confirm or otherwise, or maybe you might wish to write later on, has any DWP investigator, official or witness at any point retracted evidence given on oath to any Crown Court?
Well, I need to write to him on that specific point, which I will do. So, as my colleague and the other Police Minister, Hollingray, said, we want to minimise any pause between the bill coming into effect and redress payments being made. To be clear, the GLO compensation scheme is independent of Post Office. As requested by postmasters in our consultation, it is run by the Department of Business and Trade. Claims which are not agreed will be assessed by a panel whose members are independent of the Government and Post Office. Any errors in decisions in the independent panel can be taken to the reviewer of the GLO scheme, Sir Ross Cranston. The Government is funding postmasters with overturned convictions to receive independent legal advice on their claims and offers. Retired High Court Judge Sir Gary Higginbottom has been put in place to chair an independent panel to resolve disputes on pecuniary losses. Horizon Shortfall Scheme claims are assessed by an independent panel of experts who provide a recommendation to the Post Office. To date, there have not been any instances where Post Office have offered a lower amount than the recommendation of the panel. Turning to accountability of Post Office executives, again raised by the noble Lord, Lord Seeker, and Baroness Jones of Moulscombe, we will await the outcome of the Wynne inquiry, which will provide clarity on this issue. Finding people guilty without looking at all the evidence is how we got into this mess in the first place. That is how postmasters are prosecuted without proper disclosure. We must not make the same mistake again when it comes to holding people accountable for this scandal, however tempting it might be. I think the public can be very reassured at the detailed investigation being conducted in public by Sir Wyn Williams, and each week reveals more shocking news, and justice will be served by that inquiry, I have no doubt. A number of noble lords quite rightly mentioned Fujitsu, and of course Baroness Jones of Moulscombe has raised this a number of times in this chamber, and its role in the scandal. It is right that the company has voluntarily decided not to bid for future government contracts for the time being, while the inquiry is ongoing, unless the government asks them to. The government also welcomes Fujitsu acknowledging that they have a moral obligation to contribute to compensation. The government is in active conversations with the company at a very senior level about this. Turning to computer evidence, and I thank noble Lord Brown of Ladyton on this on a number of occasions, who has raised this consistently on the concept of the interrogation of computer evidence used in prosecutions. Now, of course, the government is committed to preventing any further miscarriages of justice like the Horizon scandal. There has been a proliferation of digital material in modern criminal cases, particularly in cases such as fraud and serious sexual offending, but also in lower-level, high-volume offences such as drink driving. For this reason, any hasty changes to legal position risk serious and significant unintended consequences for the running of the criminal justice system. However, the Lord Chancellor is fully considering all options available, and more consideration will be given to this, can be given to this matter and reported to the House through this process. In terms of territorial extent, again, I thank noble lords, Lord Brown of Ladyton, noble and learned Lord Faulkner of Thornton, and Lord Holmes of Richmond for their comments on the territorial extent of the bill. We all wish to see United Kingdom justice being applied to all four parts of the United Kingdom. The other place has agreed to extend the bill to Northern Ireland in recognition of the unique challenges faced by the Northern Ireland Executive in bringing forward their own in a similar time frame to the rest of the UK. Their legislative process is lengthy and difficult to expedite, and the legislation would have to compete with the many other priorities accumulated during the 2-year suspension of the Assembly. The Government was also cognisant of the extent of cross-community support for the extension of the bill to Northern Ireland. The Government's position on Scotland remains unchanged. Scotland does not face the same challenges in bringing forward legislation within its Parliament as Northern Ireland does. And it is for the Scottish Government to bring forward their own proposals to address prosecutions and for those to be scrutinised by the Scottish Parliament in line with the devolution settlement. I hope that it reassures the noble lords, the noble landlord Lord Fulton of Thornton and Lord Holmes of Richmond, that my officials have been supporting their counterparts in the Scottish Government to bring forward their own legislative proposals. I understand they intend to do this shortly. Turning to another one of the very uncomfortable situation raised by this Horizon scandal, which was raised by the noble Lord Sahota, who spoke so powerfully about the racism experienced by victims of the Horizon scandal. And I agree that this issue is very important. And Sir Wyn Williams' inquiry has touched on this already in its oral evidence sessions. And the Government is keen to hear anything the inquiry concludes on this matter, including any recommendations for the future. Turning now to an issue raised by Noble Baroness Brinton in relation to Capture, which indeed was the precursor computer system to Horizon. At this point in time, we have not found sufficient evidence to conclude that Capture led to people being wrongly convicted. Capture was very different from Horizon. It was a standalone spreadsheet, not an integrated accounting system. There were bugs in it, but they were admitted to by the Post Office. It was not an interactive system that could be manipulated by a third-party source, as was the case in Horizon. It helped postmasters balance their accounts rather than operating as a black box reporting accounts across the network to Post Office headquarters. Given the limited information we currently have about Capture and resulting convictions, there is not yet any evidence that any miscarriages of justice took place. It would therefore be our position on behalf of the Government not to seek to overturn these convictions or to consider Capture cases within the Horizon system inquiry. However, I would like to reassure the noble lady that we are looking into what can be done on Capture. As soon as the Government found out about issues with the Capture system, we asked the Post Office to investigate. We're in the process of appointing an independent forensic investigator to look into the Capture software and how the Post Office addressed concerns about it. Once the investigator has reported, we will return to the House to set out our plans, but we do not consider that this should be allowed to hold up the more important matter before us, which is overturning the Horizon convictions. Turning to the post-legislative process, I'd like to thank Noble Lord Sandhurst for his very useful contribution with his 2 points. The creation of a website for those who have been exonerated by this bill could assess. He's indicating the fact that we do not have full contact details for all of our claimants in this case. For reasons of confidentiality, it would not be right to create a public web page that would list the names of those exonerated. However, all those that are in scope will be written to on royal assent, and those that we've been able to identify in scope but haven't been contacted will be able to get in touch with the Government to have their cases looked into, and we will make sure that gov.uk is utilised to promote access to exoneration and financial redress. All guidance on the exoneration process and the financial redress scheme will be on gov.uk. My Lords, I'm grateful for the cross-party support shown towards this legislation and the valuable support of the opposition front benches, represented by the Noble Lord McNichol and Noble Lady Baroness Brinton. In closing, the Government recognises the profound impacts that the Horizon scandal has had on those who were falsely accused, and as I listened to Lord McNichol refer to individual cases, we all know of examples in our local area where lives have been ruined, and each one is a very sad story on its own. And therefore we legislate with that at the forefront of our mind. And the objective of this bill is to exonerate those who were so unjustly convicted of crimes which they did not commit and provide fair redress as swiftly as possible. My Lords, I beg to move.
The question is that this bill be now read a second time. As many of that opinion shall say content. Contrary not content, the contents have it.
I beg to move that this bill be committed to a committee of the whole House.
Question is that this bill be committed to a committee of the whole House. As many are of that opinion shall say content. Contrary not content, the contents have it. Okay. Questions on a statement made in the House of Commons on Wednesday, 8th of May, network outage affecting e-gates.
My Lords, can I thank the Noble Lord for the repeat of this important statement which deals with the recent e-gates outage affecting border control and security. Can I once again no doubt join the Noble Lord, but all of us who have paid tribute to the staff who responded and to the passengers who waited patiently, often many hours for flights. Our border security is something we all care passionately about and are united in recognising its importance. There are, however, of course, a number of serious points and questions for the government arising from what happened just a few days ago. This example is just the latest in a number of failures with the e-gate system. Can the Noble Lord reassure us that the government's confidence in this system has not been shaken and that the intention is still to expand the e-gate network? Is the same technical issue which has been responsible for other outages, still is it the same problem in this case as it was in previous cases that we've seen? The security of our borders is of course crucial. So can the Noble Lord confirm again that the outage was a consequence of a technical failure and absolutely not of any malign actor? Can the Noble Lord also confirm that although the system was down for a number of hours, that no aspect of our border security was compromised in any way? And can he confirm that there was no cyber element to the attacks, and so weaknesses which could be exploited by any adversaries? In discussing this matter, the Minister in the other place said, and I quote, "How we got to this point in the first place, as soon as the fix was put in place, the posture changed to getting us to a place where we better understood the root cause. That work is ongoing and it would be not right for me to speculate on it." So, my Lords, the question for the Noble Lord is there still a problem that we've put a sticking plaster on, calling it a fix, whilst the root cause as yet unidentified remains? If so, what are we doing about it? Can the Noble Lord also reassure us all that any lessons learned are being implemented as a matter of urgency and that all of the contingency plans that were in place are being reviewed in light of how well they did work or maybe didn't work? As an aside to this particular issue, can the Noble Lord also take the opportunity to give a guarantee that all preparations that are necessary are in place when it comes to Dover when new entry and exit checks are introduced in the autumn? Alongside this introduction of e-gates, automation and new technology, doesn't the recent issues that have arisen highlight once again the need for a visible physical border force presence at our ports. Yes, people to help and advise, of course that is crucial and important, but also those whose job it is to ensure compliance with and the enforcement of our laws at the border. There cannot be another repeat of the chaos we saw recently at our borders. These problems do seem to be too persistent and occurring on a regular basis. That undermines the confidence of all of us in the security of our borders. It undermines that public faith, which is so crucial to the integrity of our country, and we all have to believe that our border security system works and works well, because that is in all of our interests, isn't it?
I too pay tribute to the staff involved, both the border force staff and other airport staff who took the pressure of the time when this occurred. It is now 5 days on from when this statement was made in the other place, and understandably the minister there was able to give only limited detail and indicated that investigations were ongoing. But clearly there is going to be more known now than was known at that time. So can the Noble Lord the Minister give us more detail and a commitment that when the final report is produced, that he will return here to inform us about the lessons that it has revealed? Because getting this right is obviously vital. We were lucky, the government was lucky this time. It occurred in midweek, in early May, early evening. A quiet time of day, at a quiet time of the week, at a quiet time of the year. If it had occurred at peak time, the story would probably be very